The decision by the Supreme Court on the release of the assassins of Rajiv Gandhi is highly discouraging, dispiriting, and it is entirely untenable, undefendable, and inarguable. Friends, justice has to be done, but also has to be seen to be done. Today, the Honorable Court has ordered release of 6 convicts who had carried out the brutal, premeditated, and heinous assassination of a former Prime Minister of the country, the late Rajiv Gandhi. This release has shocked the nation's conscience and has invited serious concern and criticism from all sides of the political spectrum. Following a previous judgment of 17th May, when another person was released, relief was granted to 6 convicts today to allow them to walk free. Now, I'd like you to please focus on the 6 reasons I am giving why we object. But before that, first it sends a message to the world, an undesirable message, that we extend to these killers the benefits of our judicial magnitude and largesse, forgetting the nature of their crime. After all, they murdered in cold blood and by deliberate design a former Prime Minister. Second, even the Supreme Court has repeatedly said in other judgments that there is no blanket guarantee to be released just because you have served a certain amount of time. The court observed many judgments are there. One of them is Gujarat versus Narayan. There is no absolute right to release, and each case must depend on the context and facts of his own case, individual merits. Third, the Supreme Court has justified its decision today and the 17th May decision, saying that the release was recommended by the state of Tamil Nadu. Our most humble and respectful view is that the ultimate arbiter in these matters is the Supreme Court, not the state of Tamil Nadu. And to give this dispositive weight to the Tamil Nadu government is itself legally erroneous. Therefore, we frame the following questions for the nation through you in the light of today's verdict. Question 1. Why has the Honorable Apex Court, despite being aware of the nature of the crime, the evidence that led to their conviction, the previous objection of the governor, even sought to grant preferential treatment to those individuals who were convicted, I repeat, convicted, of so reprehensible, so horrific, and so heinous a crime? Second, how will the Apex Court in the future deal with similar claims by several other similarly placed or even less seriously placed criminals or accused, or rather convicts, not accused? How can the Supreme Court now refuse other similar claims, regardless of howsoever heinous a crime has been committed? Friends, third, if ill health is a ground for release, if good behavior is a ground for release, if conduct in custody is a ground for release, then why are so many individuals still in custody across the country, especially so many suffering under charges brought by this government? The Honorable Supreme Court cannot be selective in applying these standards. Most important, friends, is the fourth point I am making. The assassination of a former Prime Minister stands on a totally different footing. Irrespective of political color, such a person is reflective of the insignia of the sovereignty of the country. In that sense, a fatal attack on any PM, former or sitting, is an attack on the very sovereignty and integrity of India and cannot be dealt with on normal administrative considerations. And therefore, we endorse and support the very clear stand of the central government, which did not agree with the state government on this issue. If the petitioners before the court, that's the fifth point I'm making, were seeking relief, so the petitioners before the Supreme Court were seeking relief, the principal respondent, the state, was supporting the petitioners. Then it was incumbent upon the Honorable Court to not only call upon the central government as they did, but to give a lot of weight to the fact that the central government did not agree with the state government. The degree of weight, the dispositive weight given to the state government is disproportionate to the weight given to the central government's view. And we believe that not sufficient weight was given so that the central government's clear disagreement with the state government could be fed into the calculus appropriately. Sixth, the somewhat strange and possibly unintended effect of this order, strange and possibly unintended, hopefully unintended, would be that any recommendation by any state government would be virtually binding. And it would be taken as virtually dispositive by the Supreme Court, which cannot be correct. And most important, lastly, not the least, but very important, this is underlined by the fact that the court itself was cognizant of this because they used their special unique powers under Article 142, which is indicative of the absence of their power to do a specific thing. Because 142 is used only because you don't have the power and you want to do some overall special justice, which only the Supreme Court has the power. The Indian National Congress respectfully believes that this is a wholly inapposite invocation of the drastic, ad hoc, and unique power of the apex court in a case involving convicted assassins of a former head of the Indian government, which, as I have explained earlier, strikes at the very root of Indian sovereignty. Without going into specifics, I only want to say that we intend to take all appropriate remedies available to us, be it review or any other form of legal redress, because we believe that we owe it to the people of this country and to the Supreme Court also on the legacy which it has built itself.